Ortiz versus United States, decided in 2018, arose out of a service member's conviction by a court-martial. Keanu Ortiz lost his appeals at the Air Force Court of Criminal Appeals and the Court of Appeals for the Armed Forces, known as the CAF, the tribunal that sits atop the military courts. Ortiz then obtained a writ of certiorari from the Supreme Court, raising issues under the Appointments Clause and a federal statute governing dual appointments. There, in an amicus brief, I asked the court to address its own jurisdiction under Marbury v. Madison before reaching the merits of Ortiz's case. Under Marbury, the court can exercise appellate jurisdiction only to revise an already instituted case, not to begin a case. Chief Justice Marshall reasoned that the court could not exercise appellate jurisdiction over the Secretary of State, James Madison, because he was an executive branch officer and not a court. Similarly, the CAF is not an Article III court. Its judges do not possess the Constitution's required life tenure and salary protections, and it is housed within the executive branch. For that reason, I argued that the CAF was in fact an executive branch body wielding executive authority, much like Secretary Madison, and therefore the Supreme Court could not directly exercise appellate jurisdiction over it. In a 7-2 decision, the Supreme Court held that it could exercise appellate jurisdiction over the CAF. On the merits, it went on to affirm Ortiz's conviction. Justice Kagan's majority opinion claimed that the CAF's non-Article III status does not prohibit the Supreme Court from directly reviewing its decisions. The opinion analogized the CAF to other tribunals that the court can review, namely the courts of other sovereigns like states and territories. Justice Thomas filed a concurrence arguing that Congress's powers over the military are so exceptional that it can create courts exercising judicial power outside the confines of Article III. Justice Alito authored a lengthy dissent joined by Justice Gorsuch, arguing that the court could not directly review the CAF because it was housed within the executive branch. He claimed that the majority's analogy to territorial courts was inapt because Congress enjoys a unique authority over the territories. And he countered Justice Thomas's argument about military courts by contending that the Constitution vests the judicial power of the United States, every single drop of it, in Article III courts with life tenure and salary protections. The three opinions reflect different visions of the concepts of judicial and executive power. That is a question that comes up all the time in the court's separation of powers jurisprudence. Whether in cases about which tribunals can properly decide which cases, or which officials can remove or direct persons who act on behalf of the federal government, the question of what's judicial and what's executive recurs in a wide range of cases. In that sense, Ortiz requires us to confront one of the oldest and most foundational constitutional questions of them all. What is the nature of our tripartite system of government?